When my siblings and I decided to represent ourselves in probate court, we had no idea what the entire process would look like. At the time, we weren't thinking about trial. We were just trying to figure out how to begin. We were completely lost. We didn't even know which court to file in or that we had to file anything at all. Once we realized we needed to file a petition, it felt like we were stepping into the unknown. We had to figure things out one step at a time. It was like driving down a dark road where we only see a few feet illuminated by our headlights. We had no idea what was around the next bend. It was overwhelming, and honestly, it was scary. Looking back, I think the process would have been felt more manageable if we understood the big picture from the beginning. That's the purpose of this video. My name is Angelique Hamani. I'm an educator, not an attorney. The information in this video is for educational purposes only and should not be considered legal advice. I'm simply sharing my experience representing myself in California probate to help you understand the general probate litigation process. Keep in mind, every case is different. Some cases settle early, some follow a different path, and few go all the way to trial. My goal isn't to tell you exactly what will happen in your case, but to give you a roadmap so you have a better idea of what may lie ahead. If you've been disinherited, received less than you expected, or aren't getting the answers you believe you deserve about a loved one's estate, you may eventually decide that you need the probate court to step in. For many California probate disputes, that process begins with filing a petition. A petition is a formal written request asking the probate court to make a decision. It explains what happened, how the law applies to your situation, and what you're asking the court to do. Writing a petition involves much more than just filling out a form. In the next video, I'll walk you through the three parts of a probate petition and explain how I approached writing mine. Once you filed your petition with the court, received a hearing date, and served the required notices, the other side has an opportunity to respond. Their response tells the court whether they agree with your petition, disagree with it, or believe the judge should rule differently. The other side may file a response or an objection explaining why they disagree with your petition. They may challenge your legal claims, raise their own arguments, or ask the court for a different relief. Just like your petition, their responses become part of the court record and helps define the issues the judge will eventually need to decide. As your case moves forward, you'll likely attend a series of court hearings. At each hearing, the judge addresses the issues that are ready to be decided. That may include reviewing probate notes, hearing legal arguments, ruling on motions, or scheduling the next steps in the case. Some hearings are very short and deal with procedural issues, while others involve legal arguments or important decisions that move your case forward. If you'd like to see what happened during my first probate hearing, I'll link that video at the end. As your case moves forward, it may enter the discovery phase. Discovery is a process where each side gathers information and evidence before trial. It's one of the ways both sides learn more about the facts of the case, the claims being made, and the evidence that may eventually be presented to the court. Discovery can take several forms. It may include requests for admissions, where the other side asks you to admit or deny certain facts, interrogatories, which are written questions that must be answered under oath, requests for production of documents, where each side asks the other to produce documents related to the case, depositions, where a party or witness answers questions under oath before trial, and subpoenas, which are used to obtain testimony or documents from people or organizations that aren't directly involved in the case. We'll take a much closer look at each of these in a future video. Before trial, the parties are often given an opportunity to try to resolve the dispute without going to trial. This can happen through informal settlement discussions, a court-ordered mandatory settlement conference, or mediation. During settlement discussions, both sides talk about whether they can reach an agreement without going to trial. They may negotiate different options, discuss possible compromises, and decide whether all or even just part of the case can be resolved. A mandatory settlement conference, also known as an MSC, is a court ordered settlement meeting and is typically provided by the court at no additional cost. On the other hand, mediation is another option, but it usually involves hiring a private mediator, which often comes with additional costs. If the case isn't resolved through settlement, it may proceed to trial. This is where each side has an opportunity to present their evidence, call witnesses, and explain their case to the judge, who will ultimately decide the issues before the court. During trial, each side makes an opening statement, presents evidence, questions witnesses, and explains why they believe the court should rule in their favor. Once both sides have presented their case, they'll make their closing arguments, and the judge will either issue a ruling from the bench or take the matter under submission and issue a written ruling at a later date. Every probate case is different, and not every case follows these exact steps. Some steps may happen in a different order, some may overlap, and many cases are resolved before reaching trial. My goal today wasn't to teach you every detail of probate litigation. It was to give you a roadmap so that you have a better understanding of the process of what may lie ahead. If there's one thing I hope you take away from this video, it's that probate litigation isn't one big event. It's a series of steps. And when you understand those steps, the process may start to feel a little less overwhelming. In the next videos in this series, we'll take a closer look at each step. If you found this video helpful, please subscribe to my channel. My goal is to help self-represented litigants better understand the California probate process, one step at a time. Thanks for watching, and I'll see you in the next video.